Um, Good afternoon. My name is Eric Hauge, Executive Director of Homeline, and you're joining us today on Wednesday, December 16th at 1:30 in the afternoon for Homeline's regular webinar series this year. This will be our last of 2020, where we discuss and answer questions related to tenant landlord issues during the COVID-19 pandemic. Again, we've got a 90-minute session today from 1:30 till 3. And we're joined by Mike Vra, Managing Attorney and Hotline Director here at Homeline. And so thanks for joining us. Just a reminder for any folks that are joining us for the first time, Homeline's a statewide nonprofit organization. Our main program is a free and confidential legal hotline that any renter in the state can contact for advice. And we've advised over 250,000 renter households through since we opened. Our services are available in English, Spanish, Somali, and Hmong languages. There's our hotline number and our main number and toll-free number from outside of the 7-county metro area, and direct language lines too for folks hoping to access our services in different languages. Again, we've been doing these seminars since about mid-April, and have sort of reverted to an every other week or so seminar. So this will be our last webinar for 2020, and we'll return on January 6th, Wednesday, January 6th, to discuss. Oh, this didn't get updated, but to discuss. Today is our final webinar of the calendar year, and we'll be discussing the extension of this eviction suspension that just was finalized earlier this week. Our next one, as it says at the top there, will be on January 6th, and our intention then is to kind of give updates as to what's going on both on a state level and a federal level, as the CEC moratorium is set to expire at the end of the year, although there is news percolating on that right now even. Okay, so again, on our website, we have all of our previous recordings of seminars, and actually our November 18th seminar, when we were joined, I think that's when we were joined by Larry McDonough. The CLE credit for that was just approved, so we'll be sending out information about that. But all the previous seminars are available on our website, as well as other materials. We did get a few questions in advance for today, but again, our intention is to briefly cover the situation here in Minnesota, and then leave plenty of time for questions at the end. So with that, I'm going to hand it over to Homeline's Managing Attorney and Hotline Director, Mike Vra.
Thanks, Eric. And if you could go back to the screen prior, we'll just make the quick correction. So what Eric was concerned about is that the expiration date is wrong. It's now been expired. It was extended, I'm sorry, the Minnesota moratorium on Monday through the middle of next month. Okay, thanks, Eric. Go on to the next screen. And it looks like we got somebody asking a question about no volume, that they're not hearing us adequately. If somebody could confirm that they are hearing us, so then we could make sure that it's not everybody that can't hear us. Can anybody else? Okay, thank you, Wendy and Jackie. I appreciate it. We got lots of people saying they can hear us. Okay. So Kimberly, any theories, Eric?
Can you hear me, Mike?
I can hear you fine. Yes.
Okay. Well, hopefully other folks can hear me. I'm not sure if I had my microphone down or what, but you don't need me that much. We'll let you cover most of it. And
can you try sending Kimberly some sort of tips?
Will do.
Thank you very much. All right, let's get started and talk about the big question in Minnesota landlord-tenant law, which has been the big question since March. This is sort of the banner headline in this area of the law is, when can landlords file evictions again? And what we're really talking about when we say when can evictions be filed again is, when can non-payment of rent evictions be filed again? That's the ones that really matter. Well over 90% of evictions in Minnesota are filed for non-payment of rent. And so those are the eviction moratoriums that really are hindering a landlord's ability to file their normal operation course of business evictions that they feel like they need to file. There are, of course, other reasons why landlords file evictions. If somebody has an unauthorized occupant or a pet or some other lease violation, the landlords similarly can't file an eviction for those reasons. But like I said, the one that really matters is non-payment of rent. Anyhow, how I've been explaining this since April is that a landlord has to get past a number of hurdles in order to be able to file an eviction. And right now there are still, I think, 3 hurdles that a landlord has to be able to get past, or else, once again, they simply aren't allowed to file an eviction against a tenant. The first and the most important hurdle, this is the biggest hurdle that a landlord has to get past, is the governor's executive order, which bans evictions largely. And this is tied in time to the governor's peacetime emergency declaration. So when I say it's tied in time, the peacetime emergency declaration is a 30-day increment that the governor has available in a peacetime emergency. We're not technically at war, so this is a peacetime emergency declaration. A governor can issue 30-day executive orders. After 30 days, the governor has to decide to reissue another order, or that's one way the peacetime emergency could end. The governor decides simply not renew the peacetime emergency, or the legislature can also end the peacetime emergency, or I suppose the Supreme Court in Minnesota. I think it would probably have to be the Supreme Court in Minnesota. I suppose the Court of Appeals could try it, or even the district court, but it would probably get to the state Supreme Court quickly if that was decided. Anyhow, one of the 3 branches of government has to end this peacetime emergency. The governor has the unilateral power to simply renew these 30-day increments, as near as we can tell, indefinitely. The legislature has a mechanism in place to stop the governor from continuing to renew these, and the courts probably could rule that as well, but they haven't so far, which leaves us with the legislature, really. And logistically, where we are right now, as mentioned, on Monday, the peacetime emergency was extended by the governor once again. So at the legislative level, the Senate and the House have the ability, with simple majorities in each chamber, to end the peacetime emergency as well. So what I mean by a simple majority is if you have more people voting for ending it than not, then the peacetime emergency would end. So there have been several votes throughout this calendar year at the legislative level. Every time the governor has declared a peacetime emergency when the legislature wasn't in session, a special session is automatically triggered. Normally, these have to be asked for or called for by the governor, but whenever the governor is extending these peacetime emergencies, a special session happens automatically. And the theory is behind that the legislature should go vote to decide whether to extend or not extend the peacetime emergency. So every month since June, I want to say, the legislature has been voting on whether to extend the peacetime emergency or not. And every month since June, except November, the Senate, the Minnesota Senate, which is controlled by Republicans, has voted to end the peacetime emergency. The vote number has shifted through that time, but the Senate has voted to end the peacetime emergency every time that they've had a chance to vote on this.
Except for last month, I think.
Right,
I think
except for November.
Yeah.
Except for November, right after the election, when COVID was starting to really ramp up again in Minnesota. We started to see the number of hospitalizations going up, the number of fatalities going up. So on Monday, the drama that there was at the legislature, the Senate once again voted to end the peacetime emergency, and it wasn't very close. The vote wasn't very close. Again, controlled by Republicans. Governor's a Democrat. And the House is controlled by Democrats. There's more Democrats in the House than there are Republicans. So it was up to them, once again, to decide whether to extend the peacetime emergency. And as I understand it, they went late. They went well into the night, past midnight. It was one vote that separated the peacetime emergency ending versus continuing on. One of the theories on this is, because not everybody voted, one of the theories is that some of the legislators might have actually nodded off because it was so late. I think most of them are sitting at home, and so there's nobody to elbow you saying, hey, it's time to vote, your colleague right next to you, like there would be in the chamber. And so anyhow, the peacetime emergency goes on, but it was a 1-vote difference, which has been our tightest difference to date. I think the previous closest vote was maybe in September or October, where there were 3 votes separating the sides in the House. As long as the House and the Senate continue to not end it, as long as the governor continues to renew it, and as long as the court doesn't rule against it, it looks like this eviction moratorium at the state level could go on, in theory, indefinitely. As mentioned, there are exceptions to the rules when a landlord is able to file an eviction right now. If the tenant seriously endangers others in the property, if there's significant property damage, if they violate a statute that talks about no drugs or illegal weapons or prostitution or stolen property on site, or if the landlord wishes to move in. So if it's the end of the lease, it's a month-to-month lease, something like that, and the landlord wants to simply move in and take the place over for themselves or a family member, there's an exception built into the governor's order for that. That version of the governor's eviction moratorium has been essentially unchanged since August, early August of this year. It's the 3rd version of the eviction moratorium. There were a couple tweaks that the governor had made, but the August version is the same one we have right now. We've seen no indication, no meaningful indication that there's going to be any other tweaks. It seems like it'll either be extended or it won't, as near as we can tell. We don't have some magic insight into this. We don't have a plant in the governor's office and the higher levels of the Senate and the higher levels of the House to know exactly what's going to happen at each of these places. We're watching the same information come in that everybody else is watching. And then we try to interpret it just like everybody else. But that is hurdle 1. And once again, it's by far the biggest and most sweeping hurdle that a landlord has to get past. Hurdle number 2, if a landlord wants to file an eviction in Minnesota right now, would be the CARES Act. So the CARES Act is something that has largely disappeared from public discussion because most of its provisions, most of its key provisions have sunsetted. That's legislative talk, meaning it ends at a certain time. There were a lot of parts of the CARES Act, which was really massive legislation at the federal level back in late March. Again, we have a Senate controlled by Republicans, a House controlled by Democrats, and the president, a Republican. And this passed, I don't think it was unanimous, but it was awfully close, very bipartisan support for it. One of the components of the CARES Act was, once again, an eviction moratorium. This was a narrower eviction moratorium, though. First of all, it only covered evictions for non-payment of rent. So an unauthorized occupant, a pet, something like that, a landlord could file an eviction if the CARES Act was all that was standing in their way. Some states that was the case as well. There are actually quite a few states where there was no eviction moratorium put in place at the state level, so the only ones that mattered were the federal ones. The reason why we still talk about the CARES Act when we're talking about this topic is because there's a 30-day requirement after the CARES Act eviction portion sunsetted, which was in late July. And that requirement said that the landlord had to give a 30-day notice even past July 25th, which was the end, like I said, sunset date for the CARES Act eviction prohibition. So in a state where there was no state eviction moratorium, but the CARES Act covered the landlord, they wouldn't have been able to file an eviction until probably August 26th, 30 days after the 25th. Now, does it still have a stake in an eviction in Minnesota if the state moratorium went away and the other moratorium that I'll talk about in a second goes away as well? And I think it would. I think the landlord still has to give the 30-day notice. In other states where this has actually come up, the state Supreme Court in most of those states has said, yep, landlords got to prove that they've either complied with the CARES Act, meaning that they gave the 30-day requirement, or 30-day warning, I'm sorry, or that they're not covered by the CARES Act. So who's covered by the CARES Act? Well, it's all the landlords that pretty much get any kind of federal subsidy at all. And that's a pretty broad list, and I don't want to go through it all right now, but it's a long group of landlords, any kind of federal subsidy at all, chances are CARES Act is going to cover them. Plus, a landlord that has a government-backed mortgage, whether it's through Fannie Mae or Freddie Mac or something like that. And that is largely unknowable, at least on a mass level, and even on an individual level, certainly from the tenant's perspective. the landlord could find that out. They're the mortgage holder, so they could go to whoever provides their mortgage, their local bank down the street, and ask, hey, where did my mortgage come from? Who's backing it? They're probably the only ones that can really figure it out in the time frame necessary in the course of an eviction case, because eviction case is a real hurry up kind of events in general. So yeah, that's hurdle number 2. Hurdle number 1 is the state moratorium. Hurdle number 2 is the CARES Act, which is a much lower hurdle. Even if the CARES Act is in place, the landlord could still probably give a 30-day notice if they were covered by the CARES Act. But let's go on to the next page and we'll talk about hurdle number 3. Okay, hurdle number 3 is the CDC order. So, let's see, when was it? Early August, early to mid-August, the president came out with a slew of executive orders. It was like a Saturday night, and said, we're going to change a bunch of stuff, and we're going to look into evictions and look into doing something about evictions. It was a really vague executive order. But then a couple weeks later, the CDC, the Center for Disease Control, issued an order based on that president's executive order from mid-August, saying that all evictions were stopped for non-payment throughout the United States. And that wasn't just a 30-day limitation either. It was through the end of the year, the end of the calendar year. So early September through the end of December, the CDC order is still in place. Now, the CDC, do they have the power to do this is a fair question. It's always been a fair question. The legislation that really authorizes the CDC to exist and function talks about how they have power to really aggressively limit interstate transport of, like food or animals or crops, things like that, if they feel it's necessary to stop some sort of state spreading disease or virus. And the CDC said, well, we're going to extrapolate that out to say that we have the power to stop evictions, because we're convinced that if people are being evicted, they're going to be losing their homes. We're going to see more people doubling up. We're going to see more people in shelters, all of which will contribute to COVID-19 spread. So it's better for everybody if we stop evictions societally. That seemed to be the theory behind the CDC order. It has been challenged in federal court unsuccessfully by some landlords that tried this in Georgia. I think there have been some other challenges elsewhere. I haven't heard anybody having any success fighting against this in court, which is basically the government saying, when they are challenged on these things, the government saying, well, you know what, there's a pandemic, we got to do some emergency stuff. We know this isn't good for landlords. We understand that, but we're trying to stop the spread of this deadly disease. And so the courts have been essentially saying, yeah, government, you get some latitude here. Will this last forever? I don't know. The courts enforcing the CDC order, will a legislative body, will the federal Senate and federal House step in and say, we're going to end this? I suppose they could try. I think probably the fastest way it's going to stop is either the courts will stop it at the federal level or the executive branch will stop it. So as mentioned, this goes through December 31. And we have to talk politics a little bit here because you can't really get away from it. This ends in let's see, today is the 16th. So in 15 days, this order ends. And that means that in many states throughout the country, landlords will be able to file evictions again on January 1st that haven't been able to, in many cases for months, or in many cases since this all began back in March. If there was a state moratorium that sort of bridged the gap from the CARES Act through the CDC order, because there was about a little over a month where there was no CARES Act clear violation rule. I guess it would have been late August though. So it would have been 2 weeks really where a landlord could have filed an eviction in some states if they weren't CARES Act covered. Anyhow, will it be renewed is a very valid and timely question right now. It's the same question we've been facing on a 30-day increment in Minnesota every month. But what will happen on January 1st when the CDC order expires on 12/31? Well, okay. First of all, we've heard rumors and rumblings, not like we have some inside source in the Senate and the House or at the White House telling us what they think is going to happen, nor would I really trust any of those sources. Until something is signed, it seems like there's a lot of things kicked around in nationwide media about what might be, what things that are proposed. But one of the proposals that's being kicked around attached to some of the money that's being talked about being distributed through some sort of CARES Act 2 sequel is, and I don't think they're calling it that. I think they're referring it to by other names. But a 1-month extension of the CDC order has been mentioned by several sources, I think on both sides of the aisle. So why would they do a month? Well, a couple things happen. First of all, on January 21st, we'll have a new president. President-elect Biden will be sitting in that chair, and one would assume would be considering eviction moratoriums, whether it's through the CDC mechanism that President Trump used or some other executive approach. Will the legislature consider an eviction moratorium again as part of some grander deal? It's possible. It happened back in March, when again a divided legislature at the federal level still came up with something that both sides could live with. Will President Trump extend this during his time in office? This is going to end during his time in office. And let's say that there's no deal between the Democrats and the Republicans. Does President Trump want to preside over a situation where there will be massive evictions filed in his last 3 weeks in office? And he might not want that. He might prefer to simply add it on for another month or 3 weeks or 2 months or a year. We don't really know what the president might do, which I think is an understatement on a lot of levels. But on this particular issue, I'll be really direct. I was surprised personally that this order was issued at the federal level, the one in September from the CDC. It was broader than I thought they'd try anything to be. I didn't really understand the source of it, and I'm not sure I still do, the CDC being the source of the power to do it. But that's what we have. And so it's really an unknowable thing what will happen with the CDC moratorium. I will say that the political pressure on the governor seems to have lessened from landlords saying, hey, the governor is the one stopping us from being able to file an eviction since the president's order. Because what the CDC order is in Minnesota is it's a backstop. If the state moratorium went away on evictions, the CDC order would still be there to stop landlords from filing evictions for non-payment of rent. So the one advantage politically of this from an eviction concerned perspective is if a landlord is upset at the governor for the eviction moratorium, I get it. Landlords are struggling to pay their mortgage and their utility bills and their upkeep costs, and they might not be getting the rent from all their renters. We know they're not getting the rent from all of their renters. But it's really hard to blame one political persuasion right now for that if you're a landlord. I mean, there's the governor's order, sure, but there's the president's order too, and they're really different political animals. So yeah, the governor's pressure from legislators, state legislators, and from Minnesota landlords to lift the eviction ban lessened substantially in early September when the CDC order stepped in. And it's still that same vein, although I think in this last vote, it's probably something that was considered more as the CDC order is going to lapse on December 31 unless something else is done. So the vote on Monday at the State House about whether to allow the governor's peacetime emergency to go on probably was at least on some level considering that factor. At least that's my best guess. A couple points I should mention about the CDC order, things you see on the screen here. The CDC order is only about non-payment of rent. So it doesn't stop a landlord from filing an eviction for the dog or the unauthorized occupant. It is not a cancellation of rent. That has not been the case with anything, whether we're talking about the CARES Act, whether it's the state moratorium on evictions, the CDC order, every single one of them explicitly states that the rent is still due. That fact has remained constant through all of these executive orders or legislative orders. We have heard talk immediately when the world stopped back in mid-March. Within days, we were getting calls from tenants saying, we want to go on a rent strike. How do we do a rent strike? Or how do we cancel our rent? We need to get our rent waived, or however they wanted to phrase it, which to my knowledge hasn't really worked in any jurisdictions. I think a tenant can ask for that. A landlord can waive it if they wish, but there's no law that says that this is happening, certainly in Minnesota. The rent is still due. A question we've consistently gotten about rent since this all began is about late fees. Many Minnesota landlords have late fees built into their lease. A landlord can charge up to 8% of whatever a tenant owes for rent. Many landlords simply charge a $50 late fee. And late fees, the only order of the three that I've talked about or legislation that banned late fees was the CARES Act. So the CARES Act said no late fees. So if it was a CARES Act covered property, there were no late fees allowed from late March through the end of July. And what we saw was a lot of landlords waived late fees voluntarily. There wasn't really any legal reason why they had to, but many of them waived them voluntarily, but then they seemed to stop waiving the late fees at the end of July, at least largely. And so late fees are freely applicable if it's in the lease, it's got to be in writing, and it's not above the 8% cap that we have in state law. And as I mentioned earlier, the CDC order, a backstop for the Minnesota eviction moratorium, the CDC order explicitly defers to a state moratorium with more protection for a tenant. So it says it doesn't really matter. The CDC order doesn't really have an effect if there's a state or a county or a city that has a more tenant protective language built into it. The CDC order will take a step back. And as mentioned, in Minnesota, it's largely a backstop to the governor's moratorium on evictions. Okay, I'll let you go on to the next screen there, Eric. I'll let you cover this part.
Yeah, thanks. Hopefully folks can hear me that didn't before. I just wanted to, we covered this 2 weeks ago because it had just come out, but just wanted to share it again, and I'll put in the chat the link to where you can actually read this research. In early December, there was this study that was finalized, and I think they're still in peer review, but just some pretty terrifying numbers in terms of in states where moratoriums were lifted early, leading all the way up till September 3rd, because September 4th is when the CDC federal moratorium went into effect. They adjusted and dealt with other potential items that could account for some of these excess cases and deaths, and came up with this estimate that in these states where moratoriums were lifted, there were over 430,000 excess COVID cases and over 10,000 excess deaths as potentially as a result. So I'll put the links and the info on that in the chat. Then the other thing I put in the chat while you were talking about some of the negotiations is just that there have been, there's been some news, and I put some links to the National Low Income Housing Coalition. They've been calling nationally, and you can go to their website. I can maybe even put the link. You can take action. They're working on getting advocacy to Congress around extending the federal moratorium and also getting an agreement for rental assistance on a federal level. And the sort of most recent news is that there is a bipartisan agreement. It's not finalized yet, but that it does extend the moratorium through the end of January, or it will if that's what's enacted. And it would also include up to $25 billion in emergency rental assistance. So that's the rumors right now. It's not official yet. And then on a state level, as Mike was talking about too, there was also an effort to just earlier this week to increase the state dollars going towards rental assistance with the end of the Minnesota Housing's COVID housing assistance program that was announced back in July. That was CARES Act dollars that the governor put towards Minnesota Housing and then was used statewide for rental assistance. That program had been going right up until, I think it was beginning of last week or the previous week, the 7th, I want to say it was. And so that you can no longer apply for that. And so there was this hope that the state could fill in the meantime and have a program that continues beyond December. And that those negotiations failed, at least during special session. Okay, Sorry, I'm missing my, I think that was all I was going to add on that, unless you had anything more.
Nope. Nope. Thank you.
So again, our intention was to kind of be brief at the beginning here and then just really open it up for questions. We did get a handful in advance, so we'll jump to those first. But
Right.
please,
Before you ask them though, again, you can either submit them on the Q&A system, or if you prefer, you can do them on the chat. We'll see them either way. It's easier to track them in the Q&A, so if you have a choice, then that's better for us. But as Eric mentioned, we have about 5 questions in advance. These aren't going to take the full amount of time. This is actually every time my favorite part of these sessions, because I never know what somebody's going to ask. These are very unfiltered, unscreened questions. And so it's a chance to talk about some issues that are on your mind. We do focus on COVID-19 related questions, although we take various landlord tenant type questions as well. So we're planning on being here till 3 o'clock, unless we run out of stuff to talk about, but that's really up to you. If you want to ask a question, feel free. If you want to make a comment, we can share the comment and comment on it as well. But we have a handful now, so I think you were going to start with the questions, Eric, that we had in advance.
yeah. All right, so Emma asks, have there been any updates on if landlords are allowed to raise rent during the peacetime emergency?
Yeah, it's a good question, Emma. It's actually a complicated question. There's a couple answers to it. First of all, very early on, I think this was almost simultaneous with the eviction moratorium, there was a price gouging executive order issued by the governor as well. The price gouging order limited increases on prices for essential goods. It wasn't just for rentals, but rentals were certainly in that grouping. And it said that prices couldn't go above 20% the price that they were. I can't remember, it was a month before the pandemic declaration had been listed. Eric just put that in the chat box. And as I'm sure you've all seen, the chat box is where he's posting all the links to a lot of these things. So if you don't have your chat box open, you should open it up to see what he's talking about. That was Executive Order 20-10. If you're trying to find one of these executive orders, they're actually pretty easy to find online. You just type in Google Minnesota Governor Executive Order EO 20, that's 2020, that's what we're talking about there. And then it's number 10 is the one we're talking about there. So EO 20-10 has the 20% cap on price gouging for essential services. And that's been in place since the pandemic began. It hasn't gone away. I think it's tied also to the peacetime emergency declaration. We all remember the toilet paper and hand sanitizer runs earlier this year, but there was a price gouging limit on those things as far as what people could charge, or at least what merchants could charge. I think there was probably some aftermarket, toilet paper sales on Craigslist and things like that that we heard about. And that's the limit that a landlord had. Regular rent increases, though, under the 20%, can a landlord do that legally? That's a much more complicated legal question. Our theory always has been, since the beginning of this pandemic, that a landlord couldn't do that was effectively terminating the lease if they changed the rental amount. When you think about what a lease contract is, it's really comprised of a few key, I always think of them as sort of legs of a table. And the ones that really matter are the following. We have the place, that's the actual address that a tenant's renting, the duration, 1 year, month to month, the parties, who's the landlord, who's the tenant, and what's the price. Those really are the 4 key table legs that hold up a lease contract. Now, some leases I've looked at are 50 pages long, but it's really at its core, those 4 key things. There'll be a lot of other stipulations, but they have to be there. And if you take any one of them away, the deal really has changed dramatically. So I've always viewed it as that the landlord is terminating a lease when they try to raise the rent. But I'm not the party that matters. The price gouging order, the governor's moratorium on evictions, those are enforced specifically by the governor's order by one agency and one agency only, really, which is the Minnesota Attorney General's office. And they have not aggressively gone after landlords with under 20% rent increases, arguing that it's a substantial alteration of the lease. I'm not sure if they don't agree with our assessment of that, or if they simply have limited resources and figure that they have to go after the landlords that are actually filing evictions improperly in court, or threatening evictions or changing locks or things like that. And they just have to, decide resource allocation wise what to focus on. But anyhow, that's the two-part answer to the question. Thank you, Emma.
All right, and I've seen some good questions come in too,
Yep.
so thank you. Ethel asks, how to get help with paying on previous bill you had while renting a property?
Yeah, I'm not exactly sure what she's referring to there. I'm not even sure if she's talking about rent. I think it is that she's talking about.
I think so.
Yeah. Yeah, Ethel's trying to figure out how do I get help paying a previous bill during renting a property? Well, again, what I would always tell a tenant to do right now, if they're trying to figure out what do I qualify for, what kind of financial assistance do I qualify for, is to contact 211, which is United Way's first call for help system. They have the best, most current referral source in the state. They keep a database that's current and they know what is available. Some of this is geographically limited. Some types of financial assistance are geographically limited or other types of limitations, but they have a really good referral database. That's all they do is refer people to the right place. And so I would start with them as far as a place to see what you might qualify for. They'll know exactly what there is.
Yeah, it really is on often a county by county basis. So it's good to call 211. We do have a section on our COVID page that has links to some other resources. Unfortunately, some of these have recently closed. I know that, again, the Minnesota COVID Housing Assistance Program ended applications last Monday. And then I think Hennepin County just recently ended applications last week. But the hope is that there will be more soon. And you should always check on a city and a county by county basis to find what you have, what might be available. The next question is Lindsay asking, prior 30 to 60 day lease renewal or ending lease agreement notices, are they different during the pandemic?
I think I understand the question, and I think the question is, can a landlord non-renew a tenant during the lease? Is that your sense of what the question is?
Lease renewal. Can the tenant or I guess maybe.
Can the landlord do it? Yeah.
Yeah, maybe talk both.
Yeah, no, I can answer both ways. So since the pandemic began, there's no question that a tenant can give notice to vacate. A tenant can say, I don't want to renew my lease, or my lease is ending and I don't want to have another lease, or I'm month to month, so here's my 1 month's notice or my 1 rental period's notice. That has been allowable for the tenant since the beginning. Although right away at the beginning, there was an argument that a tenant couldn't move into a new place, reading the governor's orders, not just the eviction orders, but the state shelter-in-place orders. That was remedied pretty quickly by the governor. I think that there's no question that many of these orders have been sort of done quickly. And so things were missed. That's why tweaks were made later on. But yeah, the tenant has always been able to give notice if they're at the end of their lease or they want to give proper notice under their contract, if it's month to month or something like that. The harder question is, can a landlord do that? Normal, non-pandemic times, market rate tenancy, where there's no government subsidy of any type, a landlord can say, you know what, I don't want to renew our lease in Minnesota. And the general rule is they don't even need a reason for that. And so whether it's month to month and the landlord just gives that 1 rental period's notice, or it's a 1-year lease that's ending and the landlord says, you were here for a year, we had a 1-year deal, but that 1 year is over, so you and I are done now. And that was, in the past, it was legal for a landlord to do that. And so that is not legal for a landlord to do it. Although, again, the earlier governor's orders banning the eviction moratorium, it was a little unclear whether a landlord could end a lease that way by giving a non-renewal or a notice to vacate or a notice to quit. They're referred to a lot of different things. But now the August version of the governor's executive orders, so that's number 79, the one we're still currently using for eviction moratorium. It does specifically say that the landlord can't issue a termination of the lease or non-renewal of the lease or terminate residential leases. So it answers the question much more explicitly that a landlord is not allowed to non-renew or issue a notice to vacate. I think at this point, if we had the Attorney General's office on the line, they'd probably tell us that they get more calls asking about that right now than evictions that landlords are threatening to file. That seems to be the sense that we've had. I think most landlords understand that they can't file evictions in court right now. So they're trying other approaches. And one of those other approaches is to just give a standard notice to vacate. They either know about the governor's rules or they don't. If they know about them, they're ignoring them or hoping the tenant doesn't know about them, or they don't know about them. But I mean, this kind of thing has been in the news and on social media a lot since this all began. So, but there are some landlords out there that this certainly is not how they make their living, being a landlord. This is, maybe a side job, or they inherited the rental property, or something like that, where they, I've heard the term accidental landlords or amateur landlords, people that haven't turned pro yet, and this is all they do for a living. But anyhow, that is the short answer. That wasn't a short answer, sorry. The answer on the termination of a lease question.
All right. Might need some clarification on this one, but we'll try it. Terry is asking about, I think, a tenant's rights regarding an HRA letter from, a housing authority, dated December 7th, to the tenant, requiring the tenant to vacate by 12/31. Stated intent to housing authority was to pay full rent starting January 1st, not vacate. Maybe
Yeah.
if Terry can clarify, I'm wondering if it's the tenant had said.
And Terry just put something in the chat. I'm still not exactly sure. Terry, let me just say this. If you're a renter, I would recommend that you give our tenant hotline a call and try to talk to one of our advocates, or send an email to our email and attorney service, both of which are free. Oh, okay. It looks like they have spoken with somebody in the office, which is great. Yeah, this one might just be a little too specific for us to really dive into in this kind of forum.
Yeah. All right. And again, the number's up there. Never mind. Okay. Michael asks, tenants not wearing, well, not just is stating tenants not wearing masks in common areas, just generally.
Yeah. So where we have to look on this question is Executive Order number 81. That is the mask executive order that talks about mask requirements and where they're required. And it doesn't talk about tenants specifically in common areas. It doesn't focus on that and answer it explicitly. But I think that, yes, a tenant has to wear a mask based on this order in common areas, is what the governor's order is. Unquestionably, the landlord's employees have to wear masks in common areas of an apartment building, and unquestionably, they have to wear masks when they go into the tenant's unit. I think that other tenants also have to wear a mask in the common areas. I don't think it's that tricky of a reading of the governor's mask rule. Enforcement's a different question, though. Who's going to enforce that against a neighboring tenant that refuses to wear a mask in the hallway or near the post office part of the lobby in an apartment building? And our short answer is the tenant should probably call the Attorney General's office, because that's really who's charged with enforcing this. They can put pressure on the landlord to, put more signs up, try to get more active in encouraging tenants to wear their masks in common areas. And this has been one of the things that Minnesota landlords have brought up, is why they think the eviction moratorium should either be ended or they should be granted broader powers on filing evictions. Is shouldn't they be able to file an eviction against a neighbor that's having a problem with a neighbor because one of them won't follow the mask mandate of the governor? And so this has been a point of contention for a bit now. It's always a little, one has to be skeptical when looking at a landlord's reason for an eviction. Many cases have been filed already this year where the landlord says, hey, they significantly damaged the property, or hey, the tenant is seriously endangering others on the property. The two primary ones that landlords use for the exceptions for the eviction moratorium. But the landlord will also write down, oh, and they also haven't paid rent since March. So it sort of looks like it's just a pretext that the landlord is finding some loophole to go file an eviction for non-payment, but naming these other issues. In a court case, a judge shouldn't even consider the non-payment. If I were a landlord lawyer in an eviction, I wouldn't even write down the non-payment. I think it makes it look like you're really just trying to evict for non-payment. Or if I were just a landlord filing an eviction. But right now, a landlord filing an eviction for that, they'd have to argue that the maskless tenant is seriously endangering others on the property. I think you could add some facts to the story to probably make it a stronger case for the landlord, that the maskless tenant has been diagnosed with COVID recently and they're running around, coughing on people intentionally or spitting on people intentionally. Then yeah, I think you're probably to the point where they're seriously endangering others. So I can't say that going maskless is a complete loser for a landlord in an eviction case. It's just, it's a tough one to prove. It's a tough one to show that the tenant the landlord has filed the eviction against should be evicted under the governor's orders. So it's a tough spot for a lot of people involved. The neighbors that are upset with their neighbors who don't wear a mask, and the landlord that wants to protect their residents. I get that point, but under the orders that we have, that's the best assessment I can give.
Yeah, and again, that's 20-81. I put the link to that in the chat, and we also have an FAQ on our website about it. There's a good point that Terry brings up in the chat that I think is a part of 2081. There is a section of 2081 that provides for individuals that can be exempt from the mask requirements, people that have medical conditions, etc. There's even a section in the order that says landlords have to provide a clear means for tenants and others to request a reasonable accommodation to face covering requirements in common areas. So the question that's being raised is someone who might have a health issue, whether it's a physical or mental health issue, they may actually have some sort of reasonable accommodation that they've been allowed to not wear a mask. Anything more to add on that?
No, that's a good answer. Thanks.
All right. Okay. Now we're going to jump to some of the questions that have come in during our seminar here, and feel free to submit more over the Q&A. If a tenant violates one of the active eviction orders, for example, drugs, weapons, prostitution, etc., how can a landlord get the tenant out? Is Hennepin County accepting court cases?
Yeah, short answer is every county is accepting court cases. Some cases they will shelve indefinitely. So if a landlord went and filed a non-payment of rent case in Hennepin County, you can logistically file it right now. You technically can pay your $300 and file the case, but it'll get stopped and maybe deleted for, I can't remember what they're doing in every county. There's different approaches in different counties. But yeah, you can actually have one of these cases heard. If there's an active eviction for drugs, weapons, prostitution, those are heard really quickly in the eviction context. And housing court isn't as busy as they normally are in Hennepin County. Hennepin and Ramsey County have their own courts that just do housing work. And so you're probably going to get even faster in line than you would in non-pandemic times with one of these cases. But again, that's what the landlord has to allege, is that the tenant violated, and if it's for drugs, weapons, I think they're referring to 504B 171, the statute we talked about briefly earlier, that was in place before the pandemic. It remains in place now. And it's the one of those exceptions that's part of every landlord's lease, whether it says so or not. The no drugs, no guns, no prostitution, that's built into even a handshake deal in Minnesota. Even an oral lease would have that portion of it automatically included in the lease. So yeah, that a landlord can file an eviction for those reasons. And Hennepin County is certainly hearing those types of cases.
Yeah, we're sort of monitoring eviction filings, and every week there's at least about 15 to 20 in Hennepin and Ramsey, and throughout the state probably upwards of 30 to 40 that we're seeing each week. And so Not all of them. I'm not sure if all of them, go the full distance, because they may not be following the exceptions, but they are happening. Tina asked, my rent is $10.75 a month. The late fee is $65. Is that within the 8% rate for average rent for a 1-bedroom?
I know Eric is laughing at me because I'm just punching buttons on my giant calculator. But no, that is fine. $86 would be the most that your landlord could charge, Tina, for your late rent. So $65 is under that number. It doesn't matter that it's a 1-bedroom. It doesn't matter that it's average rent. It's really just a numerical question. So I just multiplied 1,075 times 0.08, came up with 86. And that's the most that the landlord could charge. Again, not every landlord charges up to that ceiling. I think that most landlords actually don't. I think $50 is probably still the most common late fee that we see throughout Minnesota. We look at leases all the time in our office. And so don't fault you for asking the question at all. But yeah, that is within the parameters of the statute. It does have to be in your lease. It has to say it in your lease. It has to say when it kicks in, which day of the month it would become due, that the late fee is due.
I think an important point on this one too is that it's 8% of the overdue rent payment. So
right.
it can't be like, if you're multiple months behind, it can't be 8% on top of another 8%. It can be 8% of the total overdue rent payment. Yeah,
you can't compound it, sure. The other part is that it's 8% of the tenant's portion that's due. Is if there's a government subsidy of some type and the tenant is paying 30% of their income for rent, so their rent is effectively $100, then they'd only owe $8 for rent.
Okay, another question. Doreen asks, if you are the POA for an elderly parent in LTC, long-term care, power of authority, power of attorney, for an elderly patient in long-term care, can you ask your adult sibling to leave and trespass him from your parents' residence due to LEC calls, excessive trash in the yard, complaints from neighbors, that sort of thing?
Yeah, I'm not sure about the LEC acronym either. Yeah, so the question here, Doreen, would be whether the adult sibling is a renter or a tenant or not. Tenants are actually defined in state law, oddly enough, as our landlords. There's a chapter or a section of the 504B, 504B.001, which defines tenants and landlords. Tenants are defined really broadly. Basically, it's somebody who's living someplace and in exchange, they have to pay to stay there. So payment can either be cash or it could be services if they're taking care of the elderly parent or helping out with the work around the place. They could have the rights of a tenant. And so that really is the key starting legal question is that sibling a legal tenant? You might not think of them as a tenant, but the law might think of them as a tenant. And so if they're a tenant, then maybe you'd have to give them depends if they're paying anything, then you'd have to give them a full rental period's notice. If you're not paying them a flat sort of, or if they're not paying a flat sort of rent fee every month, then under 504B.135, then you would see that you'd have to give a 3-month notice to vacate. So it's a little bit complicated figuring out exactly what the person is. They might be a licensee. If you want to get them trespassed off the property, it's unlikely that you can do that. Trespassing generally requires that they somehow took possession illegally. So, I mean, you can give them a piece of paper that says you're trespassed, but whether the police will enforce that or not is a different question. And with the Attorney General aggressively enforcing the governor's order banning evictions, it's another hurdle that you'd have to get past in this kind of situation. It's not an easy question. And we couldn't advise you directly on this. If your sibling called and said, hey, this is my situation, the first thing we would try to piece together is, are they actually a renter? Are they a tenant? We only advise renters. We only advise tenants. It's clearly not you in this situation. but that would be what we would try to determine is whether or not they have the key ingredients necessary to be considered a tenant.
All right. I'm just gonna switch to here. Okay. Another question from Tina. During the CARES during the CARES Act, rent was increasing, and what was there ever a rent freeze during this time?
A rent freeze.
There hasn't been, both the state moratorium and the CARES Act and the CDC order, they've all been pretty clear that rent has continued to be due. The one difference would be the CARES Act has had the late fee.
Yeah, I think they're asking about rent increases though, not just rent being due, right?
Yeah, that might be right. Yep.
And I don't think the CARES Act had a limit on rent increases. I'll be honest, I don't know that I ever researched that part of the question because the state, well, no, I don't think it did. I'm pretty sure it did not. Pretty sure there was no specific prohibition on rent increases in the CARES Act. I just don't think that exists. I know it hasn't existed at the state level. I know the CDC order doesn't do it, but I don't believe the CARES Act did.
Okay. All right. Next question. Social worker has a question. Can you clarify which of the exceptions to the eviction moratorium need to be specified within the lease? Like if a landlord wants to evict for endangering others on the property, does that need to be a lease violation?
Okay. Well, to start, the statute that we've talked about a couple times already, 504B 171, does not have to be in the lease. So that's part of a lease. It's incorporated in every lease in Minnesota automatically, whether a landlord wants it there or not, frankly, or a tenant wants it there or not. So that one does not need to be specifically mentioned. The other parts, the only three other exceptions that we have the family member exception, we have the significant property damage, we have the seriously endangering others. So the family member exception really only works if we're at the end of the lease, or if it's month to month and the landlord wants to give a full rental period's notice. It's got to be one of those. On the endangering others or significant damage of the property, in most leases, you're going to find language that is probably sufficient to fall into either one of those categories. If it's an oral lease, a handshake deal, it's probably a tougher argument where, yeah, I think the landlord would have to show, hey, I have the right to evict under my lease. Probably also that they have something called a re-entry clause, a right of re-entry clause, which in Minnesota is required in a lease if a landlord wants to evict for some breach of the contract. But it would be a rare written lease in Minnesota that wouldn't have some language that a judge would say is enough, has enough in common with the governor's order to enable the landlord to file an eviction at that point.
All right. This is a lengthy one. Let me see here. I'm not sure if we're going to be able to get to the detail of this one. A tenant is saying they'll be advised by Homeline here that they don't have to pay rent and can block access to the landlord to do maintenance, and following advice is they're building a case against us. I want clarification. What would you advise a tenant in that case? There was mold in the basement that was addressed earlier in the spring. After a non-payment issue, tenant has brought up mold with no specifics. Realized it's a different area, went and remedied it right away. Tenant is claiming landlord owes for deposit, back rent, moving expenses, future rent to complete a lease elsewhere. Okay,
so this is, I think, the first time we've had something so direct like this. I'm an attorney, and our office has 8 attorneys working in it currently. And we are never allowed to give advice to 2 sides of a conflict. Now, this anonymous question is explicitly saying that we're advising somebody on the other side. In general, lawyers are allowed to appear on TV programs or on webinars, radio shows, and answer kind of general type questions, knowing full well that a conflict in theory could occur. And but this one is a little more, hey, I want to try to get advice from you guys, even though you're advising the other side. And so that I don't think I can legally do. I can say this, there's a couple issues that you brought up. We have an entire position paper written on the can a landlord come in during COVID-19 question. And if Eric could put that in the chat box, that would be great. And it answers that question of whether a landlord or whether a tenant can stop a landlord from coming in. But as far as advising you on how to deal with the tenant that's been working with us, I think I just can't advise you on something that's so explicitly asking us to ignore a conflict of interest or a potential conflict of interest.
All right. Lots more questions coming in. So
Yeah.
we got a half an hour, so we're good to go. Paul asks, if the landlord does not renew the lease, can they evict for holding over, or only if they wish to move a family member in? Right.
So Paul's question that shows some base knowledge of what's going on here. When a landlord files an eviction in Minnesota, they have to list a reason for the eviction. Landlord, and when I talk about an eviction, what I mean by that is the court case, right? The unlawful detainer, the UD, the filing of the case that cost the landlord $300, as compared to a landlord simply telling a tenant to go, or even writing on a piece of paper the word eviction. An eviction means a court case in Minnesota. And so Paul's asking, can they evict for holding over? And that's the right way to phrase this. If a tenant stuck around, the landlord decided to not renew the lease. Non-pandemic times, the landlord didn't renew the lease or gave a notice to vacate for the end of the next rental period, standard kind of month-to-month approach. What if the tenant sticks around past that? Well, the landlord's remedy is to go file an eviction. As mentioned, they have to list a reason for the eviction. And there's only a few allowable reasons that the landlord can list. The number one reason, once again, non-payment of rent. But one of the other reasons they can list is what's called holding over. So the landlord gave the tenant a notice to vacate that was properly timed and in writing, or maybe the tenant gave a notice to the landlord that was properly timed and in writing, and the landlord was relying on that notice to vacate. In either case, the landlord would then file the eviction for what's called holding over, not for non-payment, not for a breach of the lease, but for holding over. Now that is what it would normally be called, but now Paul's other part of his question is, can they file it now? And the short answer is no. The governor's order during the pandemic says that a landlord cannot file an eviction, cannot terminate the lease, cannot non-renew the lease, unless they've got the family member exception. The only other exception would be, the significant property damage, the seriously endangering others, that kind of thing. But it isn't really what he's asking about here. He's asking about the holding over question. And so that is the short answer to that, is that no, they can't currently do it unless they have a family member moving in.
All right. The next question is again about late fees. Can a landlord charge a 5-day late fee of 8% plus charge another 30-day late charge if terms are in lease?
So I think they're asking if the landlord can stack late fees. Is that what you think they're asking here?
I think so.
Yeah. All right. So the 8% is sort of how I always refer to the 8% rule when it comes to late fees. Is it's a speed limit type rule. What do I mean by that? If you ever get stopped by a police officer or a highway patrolman and they ask you questions about what's going on and it turns out you were speeding, one thing that will not get you out of that ticket is if the officer asks you, did you see the speed limit sign? Yeah, I saw it. It said 35. Do you know how fast you were going? Yeah, I was going 60. Why were you going 60 and a 35? Oh, I didn't understand that rule. I didn't know that's what that meant. That will not work. The officer is not going to have any sympathy at all for you. You're going to get the ticket, right? And if a landlord is trying to say, I didn't understand the 8% rule, the judge is just going to look at him sort of, unsympathetically and say, it's a pretty understandable rule. Grab a calculator, multiply 1,000 times 0.08, and you realize you can charge $80, no more. So we see some landlords that charge a daily late fee, which might be what this is asking about. If you have a daily late fee, it certainly can't exceed the 8% at any point. So if a landlord says, well, I'm going to charge you $20 a day until you pay it, and I'm not going over the 8% with any of those charges. Now, you can't have a net over the 8%. It's just not going to work. And the other part of this question is what if it says something different in the lease? So what if the lease has a late fee that's higher than the 8%? The landlord is likely to say on some level, hey, wait a second, this is a contract. It's a binding contract between two responsible adults. There's no way a court can step in and tell me what to write for late fees. If I want to write in late fees of, $1,000 for $1,000 rent, who's to stop me if the tenant signs on with that? And that gets to a topic that we've talked about a few times over these sessions, but it's worth bringing up now and again. And that's the concept of unenforceable lease clauses. This happens a lot in landlord-tenant law, unenforceable lease clauses. And the reason why it happens is one very simple concept, which every legislature in the country understands. When we have residential leases where somebody lives, not commercial leases, residential tenants, residential landlords, there's a power imbalance in the construction and creation of the contract. Now, I mean, look, Walmart is a tenant in most buildings that they operate out of. Walmart doesn't typically own their buildings. They usually rent the giant space, and they have their team of Walmart lawyers sit down with the owner of that building and negotiate a deal, right? There's no presumption there that Walmart isn't negotiating at, the phrase is in the law, at arm's length. But with a residential landlord and a residential tenant, at least in Minnesota, where I have practiced since 1996, landlords don't say to tenants, hey, I'd like to rent to you, bring over a lease. No, the landlord says, this is the lease we're using. And it depends on the issue, but almost every time, if the tenant says anything about the lease, having a problem with the lease, the landlord's going to say, I don't care that you don't like lease term number 17. This is my contract. Which is odd, because it's not as though the landlord spent, hours and hours poring over, 40 different leases and extracting their favorite clauses from each one. Almost every landlord, they get a lease from somewhere. They got it on the internet. They get it from a lawyer, maybe. And if they do landlord tenant law, great. But if not, I'm not sure how much better you are by just having a lawyer hand it to you. They find the State Bar Association model residential lease, which is the one that I would use if I were a landlord. They haven't invested as much time as tenants might think that landlords have, but landlords frequently act as if this contract, they've thought about it a long time. They really love this contract, every clause in it. They're not going to change a piece of it. Again, the legislatures in the United States, in every single state knows this. And so in every single state in the country, there have been laws written, even the most conservative red states, there are still scores of laws that will override or supersede the lease contract because of that one simple concept, which is landlords write the leases. That's just how it works. And so when it comes to a late fee, the law specifically overrides the contract. So if a landlord is above the 8%, the law overrides it. This happens a lot in landlord-tenant law. The privacy law, repairs, the eviction process. Can a landlord file a lockout against somebody? Can a landlord just throw somebody's stuff out at the end of the lease? Again, most landlord-tenant statutes in Minnesota have, at least on some level, this recognition that landlords are unilaterally writing the leases. So the law is trying on some level to make it balanced and even playing field. And that's always the push and pull in landlord-tenant law, whether it's at the federal level, which doesn't really affect landlord-tenant law much, typically. The CDC order is a vast exception. But usually at the state level, although we're also seeing city rules now starting to come to the fore. Last session, we talked about a new Minneapolis ordinance that went into effect. Next March, we're going to be talking about a St. Paul ordinance that went into effect. St. Louis Park just has an ordinance that's coming online early next month. And so cities are coming up with these same types of rules. But again, all of them are rooted in the concept that landlords always write the lease. And because of that, the legislation is trying to find a balanced spot, because housing is so essential. You have to have housing, or the rest of your life is really a massive struggle. And so that's what the legislative efforts have always been, is trying to find a balance between what can a landlord, demand in a contract versus what do we need to make sure is the bare minimum that a tenant should have protection wise. Longer answer and probably not the direction they wanted to go, but sorry.
Well, and there's a kind of a similar related question in the chat here. Is there a law that actually gives tenants a certain amount of time to read your lease? For example,
Oh, somebody, yeah, I didn't see that question.
yeah, a tenant is saying the landlord wants me to read it and sign it within 2 days. Can I have a longer time to read over it?
Yeah, there's no law that says anything about that. There just isn't. And a lot of times a tenant will tell us, oh, I signed this under duress. The landlord made me sign it. I had no choice but to sign it. If I didn't sign it, I wouldn't have a home. Probably not going to get out of the contract. I will say this, we read leases a lot for tenants. If a tenant has a problem with the lease, they can email, and I don't know if Eric's going to put back on the screen our main contact information. They can email an attorney and they can attach the lease and say, hey, look, I'm really concerned about these 3 clauses. What can you tell me about them? And we'll be happy to answer the question. And we'll get you an answer usually within 1 business day, if not a lot faster.
Right. Law enforcement center calls, police calls, adult son does not pay rent or utilities, elderly parent is in a dementia unit at the nursing home. This maybe is a follow-up to a previous question. Oh, LEC calls, law enforcement calls.
Oh,
so
thank you.
that's going back to the POA.
Sure. People throw, I'm guilty of it too. I throw acronyms around and assuming that everybody has the same thoughts that I have, which is silly. But yeah, the adult son does not pay rent or utilities. Again, that's that same question that we had before. What is the adult sibling? What is their official status legally? They're not a trespasser, I don't believe, based on what was described earlier. Maybe they're a guest. Maybe they're a licensee, which is another sort of level of the right of possession. Maybe they're a renter. Hard to know. Realistically, I would probably look into talking to a landlord attorney in that situation. That's not what we are. I'm a tenant attorney. But you don't want to make a mistake with this sort of thing. And that's probably one of those situations where it's warranted to hire a landlord attorney.
All right. Any updates about cases in court challenging the CDC eviction moratorium? How long do these types of cases take? Are any likely to overturn the CDC order or significantly change it?
Okay, so updates, not really. Oh, well, we talked about these before, but there was a federal court challenge to the CDC order in Georgia. And the judge, this was one of those hurry up kind of temporary restraining order sort of petition for hurry up relief. I can't remember the exact language they used at the federal level for it. So it was heard pretty quickly. I want to say it was heard within a month and a half of the filing of the case. So I guess that's how long those types of cases take. But what I thought would happen next is that somebody would take that to the Federal Court of Appeals. To my knowledge, that hasn't been done yet. Maybe it has. I haven't followed that case that closely because we'll in our field, we'll all know about it if there's a successful challenge or the court decides in favor of the government as well. So it's not something I've really delved into deeply. I think it's unlikely to be overturned. I mean, the landlords lost at the first level. I did read the decision from the district court on that, the federal district court, and they seem to simply be deferring to the government, saying, this is kind of a, really unprecedented moment, certainly this century, and with this level of sophistication that we have. I mean, the last time we had anything like this was, 100 years ago, and we simply didn't have the federal infrastructure in place at the time that we do now, or the state level of government infrastructure either. And so they ruled in favor of the government, said this is a function that the government should be allowed to take on. And I think the second part of the question is, could the court significantly change the CDC's order? I think that's really unlikely. I think it's more likely that it overturn it completely than to try to change it, that the court would step in and tweak it somehow. I don't think the court would want to meddle in that. I think they'd either say it's constitutional or it's not. And there was I don't remember, 5, 7, 10 constitutional arguments, the sort of the usual suspects on things like these. It's a unfair taking, it's a contracts clause violation, no due process. Um, Lawyers kind of recognize all these sort of mandatory inclusions in federal overreach allegations, basically, and that's what the landlord is saying at this point.
All right. Follow up from Doreen, and they're a social worker with the homeless outreach team at the county. So yeah, this one again, I think might be one where you can contact our hotline with the agreement of the tenant if they are a tenant. Am I saying that right, Mike?
Yeah, right. Ideally, what we always want to have happen is that the tenant would send an email and the social worker could help them compose it. And then once the tenant gets the email back from us, they're welcome to share it with the social worker if they wish. There's a attorney-client confidentiality, so we need some kind of authorization from the tenant directly in order to advise through the social worker.
And I put the link back in the chat because the first one didn't work. That's really the best way. If you're trying to contact us on behalf of a tenant, it's really best to go that way, so we can coordinate it. Okay, Dan's asking, is a landlord allowed to charge arbitrary penalty fees to tenants for smoking violations or noise violations?
Okay, well, a lot in that question. I'm not sure that Dan realized all the layers there, but I'm going to attack them all. So arbitrary penalty fees imply that they're not in the contract. It's really hard for a landlord to try to collect any kind of fee if it's not in the contract. I would say it's an almost unscalable mountain from a legal perspective. That doesn't mean landlords don't try it and sometimes succeed, but if the tenant refused, what recourse would the landlord truly have at that point? If there is going to be a penalty clause in a lease that says that the tenant can be fined $100 for smoking or $50 for a noise violation, the next analysis would be, okay, is that a fair number? Why is it $100? Why is it $50? The right way to analyze that from a legal perspective is to ask it in a different way. Why isn't it $1 million? Which is absurd, right? If you're caught with a cigarette, that you have $1 million fine. Now, the landlord could put that in the contract if they wanted. The tenant signs the contract, everybody's locked in. $1 million fine if there's a cigarette. But a court's going to say, well, wait a second, that feels punitive. That feels like a penalty clause. And so what the landlord has to have, and this isn't just landlord-tenant law, it's contract law in Minnesota, is that the clause has to be compensatory, that it's compensating the landlord for what they're actually losing. So is $50 for a cigarette going to be okay? Maybe. I'd still ask as a tenant, well, show me the $50 worth of damage that you're claiming I caused with the cigarette. You got to prove that it cost you $50. And maybe the landlord could come up with some really, elaborate explanation to say, oh, if they're smoking, then, the wear and tear increases by this percent and depreciate it out over 30 years. I don't know. Maybe they could come up with $50 an explanation for it. But it can't simply be a deterrent number. They have to be, the landlord has to be forecasting what their actual out-of-pocket costs might be. Again, compensatory damages versus punitive or penalty damages.
All right. Plugging away here. This sounds like a landlord asking, are tenants required to pay utilities, including propane for heat, stove, hot water? Can we post intent to file an eviction for substantial damage, as without heat, our weather pipes will freeze and burst?
Short answer is it's a maybe. Looking at the governor's order, I looked at it again, and the language that it has, that it says that the tenant significantly damages property, which isn't past tense, but it's not really future tense either, which is what you're talking about here. I think the landlord's argument gets a lot stronger after the damage is done, which isn't exactly the landlord's hoped for answer, I'm sure, but I think they'd have to wait for the damage to be done or currently occurring. Would be the best argument a landlord could probably make as far as the, when in time the significant damage is occurring.
Yeah, and depending on the location, I mean, another option is to try to connect them with heating utility bill assistance,
Energy assistance, yeah.
energy assistance, which in
Mhm.
some areas does cover things like propane and et cetera. Another landlord question. Landlord who has several properties, family member who needs a place to move into. We want to put them into our particular house where tenant has disputes. Is there a reason we can't proceed with family moving into that house versus one of our other properties?
Well, to start, it's got to be the end of the lease of that property, or it's month to month, and you're giving them a full rental period's notice. So you can't do it in the middle of that. If I were a judge in a case like this, and I knew you were asking a question like this somewhere, just so you all know, it was submitted anonymously, so I don't think that a judge is going to be able to track that down. I think that I'd be really suspicious that this is retaliatory on its face, and that you'd have to prove that it wasn't. I think a judge could get to that point of reviewing your case in that context, since you're asking it in this direction. Because it sounds like you could send the family member to a lot of different spots, but you're sort of preferring this one because these are the troublemakers. And if their troublemaking is based on the tenant asserting their rights, you might view it differently, but that's how they view it. Then the retaliation question comes into play. Is this a landlord retaliating against a tenant using the family member exception as a pretext to get them in there? We certainly have not seen that case litigated in the pandemic era, because there just haven't been that many cases, and they'd have to get up to the Court of Appeals level before we'd probably all be seeing them. And so that's unlikely, and it takes time as well. So maybe it would work out, but yeah, I'm not sure that it, I would not, if I were a landlord, be using this as a tool to get out the troubled tenant. I just think it's fraught with potential peril.
Okay. The next one here from Katie. Let's say rent is 100.
Eric, I hear you, but you've gotten a lot quieter. I don't know if there's a way to adjust your volume.
Let me give that. Is that better?
Yeah, thanks.
Okay. Katie asks, let's say rent is $100 a month. In November, the rent isn't paid, and the landlord charges a late fee of $8. Now it's December, and the rent isn't paid, and now the total amount owing is $200 in rent and $8 in late fees. For the month of December, can the landlord charge $16 as a late fee?
And Katie, thank you for using easy math. The $100 is a nice number to make this point that you're trying to make. But what you're talking about here is sort of what we mentioned earlier, the stacking late fee concept. Can a landlord stack late fees? And I don't think they can. I don't think under the statute that they're allowed to do that. I think they can charge the $8 for November. They can charge another $8 in December, but they can't double up the late fee for December and November. I don't think a court's going to allow that.
All right.
And I mean it, by the way. Anybody else with any math questions? That's the paradigm. That's how we want it presented.
Either $100 or $1,000.
That's
very
right.
easy math. Yeah.
Yeah.
Let's see your calculator, Mike.
Yeah. It really is big.
Oh, that's a good one. Okay. Next question. Landlord wants to end a month-to-month tenancy and move into premises themselves. Is the notice period just a month, or is it a month plus the 7 days required under the executive order exception relating to a landlord moving in themselves?
Yeah, and I'll take some blame here. I didn't talk about the 7-day portion at all earlier, but that is required now for a landlord to use any of the exceptions to file an eviction against a tenant. They have to give a 7-day notice prior to filing the eviction. If you're looking at the executive order, you'd look down into number 6 would be the portion of that order where it talks about the 7-day requirement. I think my short answer is cautious advice. If I were a landlord lawyer, I would be saying, okay, you've given the notice to vacate for the end of January, let's say. It's a month-to-month lease. The rent's due on the 1st. Landlord gives a notice saying, I'm going to move in personally on February 1st, so you need to be out January 31st. February 1, the tenant's still there. I would give the 7-day notice at that point that I'm going to go file the eviction. I don't think it's the same. That's the really conservative advice. I think there's a way to read this order that it's just got to be the rental periods notice, because it does say whichever is longer in the executive order. So the cautious advice is give the full notice, but then give the 7 days on top. I think that you could give just the regular full rental periods notice. It gets a lot messier. That question's a lot harder. The 7-day part, if you're in a lease where the notice period says something like 60 days, many leases do say 60 days for a notice period. In fact, that's exactly what's defined on the first page of a lot of one-year leases is notice period. It'll say that notice period equals 60 days or 2 full calendar months or rental periods. And so it's named a notice period. That notice period wasn't named in the lease with this governor's order in mind, but it's there. So arguably in many one-year leases, even for a drug violation where you've got a tenant that's clearly a drug dealer with thousands of pounds of cocaine bagged up and ready to ship, the landlord still might not be able to file an eviction for 60 days because of how their lease is written. So the 7-day part is an interesting argument. Probably it's enough to simply give the 1 month's notice, but really conservatively, I'd probably do the 1 month and then the 7-day at that point. You don't want to file an eviction anyway. You'd rather a tenant just leave without the eviction needing to be filed because it costs the landlord money.
All right. Next question from a social worker. Are there any places in Minnesota, cities or counties that have protections for renters about penalties for leaving a lease early? For example, client has a lease that says if they want to leave during the 1-year term early, if they want to leave early during that 1 year, they must give a 60-day notice and pay 2 months rent at the time of the giving the notice and then continue to pay during the remaining 2 months. Meaning client would need to pay 3 months rent at one time. Are there any places that cap this penalty or any proposed caps on this? Basically, client feels trapped in a lease, feels like they can't afford the rent anymore, trying to leave but can't afford to leave.
Okay. So the question is asking if there's some sort of city differences between what various cities might have for rules on this issue. I don't think so. I don't think there's any city that has a specific rule that lets a tenant break a lease early. Breaking a lease isn't something we've talked a lot about during the COVID-19 sessions that we've been doing. Don't mind bringing it up right now. It's a topic we certainly get a lot of calls about, and during COVID-19 we get calls. But in general, a tenant's not allowed to break a lease. That's the short answer. And there's no COVID-19 rule that says they get to break their lease as well. There are a few exceptions to that. The ones that come up the most are if the building is uninhabitable, it burns to the ground, or there's a serious repair problem that's endangering the tenant and they can't live there physically. Domestic abuse is another one where tenants are allowed to get out of a lease. There is no state law that says that a tenant can leave because of a medical condition. There's nothing that explicitly states that. There's a handful of states, well, under 10, maybe it's 8 states, that do have a tenant can break a lease because of a medical condition rule. It's something that's been kicked around at the legislative level in Minnesota for quite a few years, but never passed. So chances are the tenant doesn't have a right to unilaterally break their lease. They can always go. If a tenant wants to leave at any point, they have no obligation to physically, stay in their space. You can rent 10 apartments if you want to around the country. You don't have to physically be at all of them. In Minnesota, you actually have to tell the landlord that you're gone because of frozen pipes concerns in the winter. But if the tenant walks out the door and doesn't pay their rent, the landlord is most likely to try to re-rent the rental unit. In Minnesota, they actually don't have to. There's no, as it's called in the law, duty to mitigate. It's one of only 7 states that has no duty to mitigate. But most landlords will try because it's a lot better bet to try to get somebody new in there that's paying the rent than to chase somebody for the rent that they might claim that they're owed.
All right, we're at 3 o'clock. We got 3 questions, so we'll
we can answer those.
Jump through these real quick. Thanks for sticking around, everybody. Again, a reminder: our next session is going to be 2 weeks from now. It's Wednesday, January 6th. We don't have the registration set up for that yet, but you'll get an email after today with today's recording and materials.
And we should know the CDC response by then. I hope.
Right. Yeah. I mean,
right.
That should happen. So. Okay. Actually, a quick follow-up from Tina on that last question. Is that considered apartment abandonment?
Well, yeah, Tina, it is considered apartment abandonment. It's not illegal for a tenant to walk out the door. And I don't want a tenant to not tell the landlord about it. They should move all their stuff out, clean the place up, give the landlord the keys, but then say, you know what, I can't stay here. I'm going somewhere else. I hope you can re-rent. And like I said, if the landlord re-rents, the landlord can't get double rent. If they had to rent for less because they couldn't find anybody else, I guess they could follow the old tenant up for the difference. But the landlord is going to try to re-rent the place. It's not a crime for a tenant to walk out of an apartment.
All right. Following up, Paul asked a question earlier about holding over. Following up on that holding over question, if a tenant is holding over and can't be evicted, is rent due?
Yeah, good question, Paul. The rent is still due from the tenant. And if the landlord decides to accept the rent after that holding over time, then I think that notice to vacate probably becomes invalidated, or that non-renewal notice. Again, it's probably illegal to give a non-renewal right now under the governor's order anyway. So I wouldn't recommend a landlord giving a notice hoping that the tenant will leave the day after the eviction moratorium is lifted. I would wait until the eviction moratorium is lifted before I'd take any action trying to terminate a lease if I were a landlord.
Okay. A follow-up, where in the statute does it address late fee not being able to be charged on total unpaid versus just current rent? Lease states late fee applied to all unpaid bills and all additional, I'm not sure. I go to the oldest balance. Didn't I put the late fee statute? It's 504B 177. So that's in the chat where it says it has to, agreement must specify it.
Yep. Okay.
Yeah.
No, I get the question. So a couple things. Number one, once again, it doesn't matter what the lease says on late fees. It can only charge 8% of the overdue rent payment. So looking at the statute itself, and I'll tell you where the argument comes from that I'm trying to argue is the right answer to this question. 8% of the overdue rent payment. That's a quote directly from the statute. So once the landlord charges the 8%, that's the 8% having been charged for that overdue rent payment. The rent doesn't become overdue once again in the following month. It's already been overdue, so the charge has already been assessed. And so that's why a landlord only gets the percentage once, is the argument. I don't think I've ever seen a landlord win that argument. Certainly see a landlord tried that. Most landlords simply follow this statute. It's about 10 years old now. At first, there was a lot of sort of refusal on landlords' part to agree with this late fee statute, but now it's well past the 99% range where landlords just comply with it. Like I said, it is a speed limit kind of rule. It's fairly easy to understand, and so landlords trying to skirt it rarely have success if it ever gets to a court.
Yeah, I mean, I've seen landlord do this who was using like a rent software, and the software was not updated, and so it wasn't doing this properly. I mean, if you're just using a spreadsheet, this might not. You're going to have to do this differently. So, okay, Amber is asking: are tenants entitled to anything if their landlord is not performing non-emergency maintenance to their apartments during COVID, or if they're closing amenities with no payment for loss of the amenities?
Yeah, good question, Amber. We actually did a position paper on amenities earlier this year. Tenants complaining about not having amenities available to them and whether or not they should get some compensation. I think they should. If the landlord is promising this in a lease or in advertising and they're not allowed to provide those things that they promised, I think that the tenant isn't getting everything they paid for, is the short answer. It can be really hard to quantify that, to figure out exactly what the number is. What about for non-emergent maintenance to their apartments during COVID? Yeah, I mean, a tenant still has the same rights to file something called a rent escrow or have a city inspector involved if they want to. So there are ways for a tenant to simply force a landlord through court ultimately to try to make repairs. And tenants are filing rent escrows. So short answer is tenants still have the right to the place being in reasonable repair.
Okay, this is a follow-up question. If a tenant just leaves, can the landlord still sue for that penalty and or send it to collections?
It's actually a complicated question. The landlord can certainly sue for unpaid rent. Can they sue for the break lease fee on top of unpaid rent, that's a different question. And maybe not. I don't know that a judge is automatically going to give a landlord all the rent. Let's say the lease goes through next June. They almost always go through the warm weather months at least. And the landlord is saying, well, you got to pay this 3-month break lease fee, plus you still owe your rent through the end of next June. I think the judge at best is going to say that the landlord is entitled to the rent through June, but not the break lease fee. The break lease fee is something the tenant can sort of unilaterally select in a lot of leases, where they pay it up front and in exchange they get out of their contract. I think the tenant's taking a sort of calculated gamble by leaving a lease early without paying a break lease fee. If the landlord is able to re-rent, well, I think they could argue that the tenant owes them their costs that they've incurred at that point.
All right. That's all the questions we got. Maybe we got one more question. We did get a comment from Kim about that the Minnesota State Bar Association standard lease or model lease specifically states 8%. So that's good because it follows the law, and she agrees there's some property management software that does improperly allow for compounding or stacking of fees.
Kim Tennyson, a landlord attorney, as always, thank you for helping us stay on the right track. Appreciate that, Kim.
Thanks, Kim. Okay, last question because we're at 7 minutes over. Can tenant call inspector and expect landlord to pay bill without giving them opportunity to remedy?
I'm not sure I understand the question.
Yeah, I'm not sure. I mean, you can call an inspector as a tenant.
Yep. There's not a bill that the landlord's paying for the inspector to come out. Is that what they're asking?
In some cases there might be, but I mean, in most
if
cases,
if it's multiple inspections and it's like the third or fourth one and the landlord hasn't made the repairs, that kind of thing.
Yeah, maybe that's it. I'm not sure. I mean, an inspector that comes out in almost every case is going to give the landlord a certain amount of time to remedy. They're not going to say it unless it's something very serious.
Right. And look, a landlord's one of their primary defenses to not making a repair is that the tenant wouldn't allow me access to the place, so I couldn't fix what they needed fixed. Yeah. I noticed in the chat box that somebody named Paul asked for the CLE ID number. This session was not advertised as a CLE. We tend to have CLE credits applied for in cases where we have had speakers, Paul. And so, I don't know, 5 or 6 of these since April, there have been CLE credits applied for, but there was not CLE credits applied for today. And Tina has one last question I see there, Eric.
Yeah. Is there something to call something that, I'm not sure what the question is. 24 hours to be evicted from an apartment. Can you be evicted that quickly? I'm not sure if that's the question, or is there somebody that you can call if you think you're going to be?
Yeah, I'm not sure who exactly the question either. So can a landlord evict a tenant in 24 hours? Well, the 24 hours has a role at one point in the eviction process, and that's at the end. If a landlord wins an eviction case, what they win is a piece of paper signed by a judge instructing a sheriff to remove the tenant. And the sheriff will come out and put a note on the door saying, tenant, you have 24 hours to vacate. After the 24 hours, if the tenant's not gone, the landlord calls the sheriff again and then schedules a move out. So there is a part of the eviction process where 24 hours comes up, but that's after the landlord is won in court, not prior to filing the case or something like that. So a landlord saying you got 24 hours to get out without having won an eviction case already doesn't mean much of anything legally. They can threaten it, but it doesn't really, it's not a requirement, and it doesn't really, like I say, mean anything.
Yeah, and I guess, you know, those types of threats of like, you have to be out in 24 hours, or I'm going to change the locks or do something like that. Those are all, they're illegal up front, but they're also additionally something the Attorney General's office right now will look into and has looked into. They've actually filed cases against landlords that have been doing things like that during the pandemic, because those are explicitly banned by the executive orders. Okay, well, we answered a lot of questions. Thanks, Mike, and thanks for everybody who attended and asked questions. Just a reminder, you'll get an email follow-up from this in the next day or two with the link to the recording and a link to registration for the next session, which is Wednesday, January 6th. And at that point, there'll be news about what happened with the CDC moratorium. And we won't quite be to January 13th, which is the next Minnesota suspension deadline, but we'll share whatever news we have at that point and answer questions.
And this is the last one of these that we've had. We know that there've been a lot of people that have watched many of these. I hope there's nobody out there that's watched every one of them. That would be a lot. Spent a lot of hours of this, but we really do appreciate people's continued interest in this topic. We do it because people seem to want to know the latest information. We try to keep it as current as we can, but thank you for taking the time to stop by and watch these.
I think not either of us have watched all of them, right? I think
That's right. Both of us
so,
have missed at least one. Yeah.
So it's healthy to take one off.
That's right.
Just skip. Okay. Thanks, everybody. Bye-bye.